This is Matt Topic. He's a main lawyer, main guy, and thanks for coming here. Before we started, we didn't know exactly who was going to be here, so we just wanted to find out if you guys could raise your hands in terms of how many of you guys are working journalists versus students. Working journalists and students. And I also teach at Loyola part-time, so I know some of you guys. Anyway, so quick just primer on me and the BGA, in case for those of you who do not know, I apologize if I'm treading ground that you guys already know. BGA is a 90-plus-year-old nonprofit organization, started to sort of root out or highlight ties to organized crime to Chicago city government, some of this we obviously still do, but sort of branched out to now to involve investigative journalism on government throughout Illinois, and we do it by ourselves in tandem with TV, radio, newspapers, and other venues, and we also do advocacy. We have an advocacy arm, but I run sort of the day-to-day investigative unit, which just does journalism. And before I was at the BGA, I was in the Sun-Times for almost 10 years, and as a reporter and editor. And just to kind of contrast real briefly the difference between the Sun-Times and the BGA in terms of FOIA. When I was at the Sun-Times, I submitted a FOIA request when I was a reporter to the Chicago Police Department. This is before the law changed a couple of years ago. The law now says that government agencies have to turn over documents in most cases within 5 business days. It used to be 7 business days. So I submitted the FOIA under the 7 business day, when the law was like that, and asking from the Chicago Police Department rundown of crime at CTA stations, L stations throughout the city. And it not only didn't take 7 days, it took 7 months before they turned over the documents, and they didn't even turn over what I asked for. They turned over these clusters of, well, you get it by beat, so you couldn't really decipher which were the worst stations and stuff like that. And they did that, of course, because they knew they'd get away with it, and because we weren't going to sue because we didn't have the money or whatever. So they toyed with us, and that was sort of the, to some extent, it still is, protocol for a lot of these agencies, just to basically blow off FOIAs and play games and all that. But the beauty of coming to the BGA is now Matt had been with Kirkland until recently. Kirkland Ellis was our pro bono attorney, filed numerous lawsuits for us with his partners and his colleagues, and among some other legal staff that we use. But now the beauty is that we basically, if there's a problem in many cases or most cases, we just sue. And we don't do it just to do it, but we don't wait 7 months anymore. We don't get played, and we found that the results have been a lot better. That we get treated not well, but just a little bit better than we would have otherwise, and certainly better than when I was at the Sun-Times. So to that end, we just recently tapped Matt to kind of come on board as be our legal counsel. He's at a different firm now, but he's now working for us as well. So we anticipate sort of ramping up our game. And in terms of filing more litigation and just and kind of knocking more heads in terms of FOIA, because it's needed. And let me just if you guys go to the website, which is bettergov.org, not now, just whenever, you can see sort of the stuff that we've done. We chronicle what we've done in terms of legal action. It's not all litigation. Some of it's complaints being filed, top one with the RDC, formal request for investigation. Audit requests, but most of it is litigation or amicus brief, stuff like that. And Matt's been absolutely invaluable in doing this. So this is sort of the body of our work, at least since I've been there 3-4 years. But even knowing that some of these agencies have reacted a lot better since we started suing, started knowing that we will sue, and have turned over more willingly documents. But even in spite of that, there are some agencies that are just so brazen and so thumb their noses at the law, in my opinion, that we still have to kind of hammer them home. One recent example, somewhat recent, past couple of years, was PACE, which is a suburban bus agency. They had I would call, a habit of, when we would submit a FOIA, they would put up every roadblock possible to not fulfill it or not fulfill it quickly or fully. It was a battle just to get the FOIA officer's email address. No, you have to put it in writing and mail it. Well, no, I'm not going to do that. I want the email address. Well, they wouldn't give it, then I tracked it down, then would submit the FOIA, and very clearly in our FOIAs, I would say this is for news, this is for a possible news story, which is standard protocol, obviously, to distinguish it's not commercial. Then I would get a letter in the mail back, this happened several times, saying, before I fulfill your request, I've received it, you must tell me whether this is for commercial purposes. Until I get that in writing, I will not start processing your FOIA request. I put in there news requests, write it back a nasty letter, and then he would send me back something in mail. You know, okay, now I received, now I'll start processing. And then they automatically kick in the extension, we need another extra 5 days. And then they would maybe fulfill it, maybe deny it. So it became like what was supposed to be a 5-day process, a month-long process. And they did this to us not once, but they did this to us a number of times until finally we were fed up. And we sued them not once but twice. And you know, we're hopeful that we're going to be getting better results from here on. So yeah, there was.
I'll talk more about like what that litigation.
Yeah.
You want to keep going?
I want to keep going. I want to keep going, but I won't.
If I shut him up, he'll just keep on.
Yeah. Another thing.
He's a teacher, right? So you probably know that.
So anyway, but I'll flip the map.
Yeah, all right. So I'm actually my second day as an attorney at Loevy Loevy. Some of you might be familiar with the firm and do a lot of great wrongful conviction, civil rights cases. I had been a partner at Herguth and Ellis. I do intellectual property litigation, but I'm doing FOIA litigation for these guys pro bono for a while. And so part of what I'm going to be doing is trying to spend a good portion of my time really growing up a more full-fledged FOIA practice. So please, 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 if you're running into FOIA issues or problems or questions, contact me because there's often a way to do it where even if there's very limited budgets, and I know that the newsrooms have very, very little by way of budgets for this kind of thing, there can be a way to make it work. So please call me anytime. So with that, I'm going to finish the case story, right? So I mean, like long history of delays and shifting stories, and just like one thing after another. We could all speculate as to why. And generally, the requests were for things that were like anyone would give it to you except for PACE. For some reason, decided they were going to be real difficult. So
It's called up.
yeah. So the case that we filed here, Bob had asked for police reports and internal accident reports involving PACE vehicles. Seems pretty straightforward, right? Public employees are driving public vehicles down public streets. We ought to know whether they're getting into accidents, whether there's problem bus drivers, stuff like that. And then aggregate drug and alcohol testing data, not for individual people, just there was actually a federally required report that they produced for 1 year, but then another year they said it wasn't ready yet. They should have given us the underlying data, and they didn't. I'm not going to focus on that. But so we filed a suit. We allege, these things are clearly not exempt. They have a pattern of delays. They have a pattern of asserting exemptions that clearly don't apply. Under the statute, that allows us also to argue for civil penalties of $2,500 to $5,000 for every violation, which is proven in a lot of cases to create some good leverage to try to get the cases worked out. If we can get a public body who's willing to like sit down and talk instead of spending a ton of taxpayer money litigating the case, which is what I'm going to talk about next. So, tried to work things out with them, and I'm a lawyer at a well-known firm, and they, just sort of sounded like they'd want to work things out. They're outside lawyer, and then just they went ballistic. We went through like 4 different rounds of like really lengthy motion practice. It was the same thing. They were just using the playbook that they did in responding to FOIA requests. Now they were doing it in litigation. They were making everything really difficult. We went through like 4 motions. They hired former Cook County State's Attorney Dick Devine to represent them, for all. I mean, it was ridiculous. And so we beat them. Like it took 4 times in a row until eventually.
I'm sorry, that was the one. That was the other one. That was the payroll one. No, this is.
Oh.
This is the bus.
Yeah, payroll. We'll do that. So they just threw up roadblock after roadblock after roadblock. I think they paid probably about $80 grand in taxpayer dollars to go through all this nonsense. Eventually, we've now gotten all the documents and we're working out, the civil penalties and attorney's fees and all that stuff. But I mean, it's just outrageous. I mean, I think in some ways things have gotten better. I mean, it's almost like nobody's paying attention sometimes to what the examples we make out of other public bodies. And they just go down the same thing. And sometimes I feel it's like the in-house counsel at some of these public bodies like are getting all, they're trying to be all macho about it and like impress their other, like, you know, their other public body lawyer friends and how they're going to stand up to the media. And, you know, because you hear the municipal legalists throw all this crap around about this outrageous cost of FOIA and like how difficult it is to comply with. And, so, yeah, that's my rant.
Well, I mean, and just to piggyback on that also, I mean, one of the problems that we saw with PACE and that we see with other agencies, this is probably no surprise to a lot of you, but that, you know, there was no email address online, there was no real FOIA policy, just, you know, here's FOIA, mail it in. It wouldn't even, I don't even think it identified who the FOIA officer was by name. And when we did, like I said, when we tried to get the email, they wouldn't even give it up. So it was just this ridiculous sort of, you know, posture against transparency.
Copying charges.
Copying charges, excessive. But anyways, the one suit that Matt had mentioned was was for the bus accidents. The other one was that we filed against PACE was for what should be one of the most basic things that are FOIA to get is the payroll, and that we asked for it in a certain format. We asked for it in Excel or a comparable format because obviously Excel is sortable, you know, movable, you know, importable, whatever. And you want to pick it up from there? What happened?
Yeah. So this is, if people done FOIA requests for like electronic data very much, Excel spreadsheets, database records, stuff like that. So this is, there's been a lot of activity in kind of this area. And the law, I think, is actually pretty straightforward, but it took a number of court decisions to really get to the bottom of that. But the law says, and it was amended in, I think, 2011, 2010, it says, if you want records that are maintained in an electronic format, then the public body has to produce it in the format that you request, if feasible. If it's not feasible to produce it in that format, then you pick. Then you, as the requester, get to pick between however they maintain it in the ordinary course of business or in paper. Right. So, happened here, Bob has requested, Pat had requested payroll data in Excel format, and they produced it as a PDF document instead.
I think it's
Yeah. Right. So Pat writes back, says, "Hey, do you have this in Excel? I'd like to get it." And their response is, "Sorry, this is the way it was sent in October 2011. I guess there have been you had asked for it."
same thing happened.
We did this before, right? And he said, "This is what I have." Now, and then if you were to scroll down, what Pat found is, if you look at the document, first of all, it looks like an Excel spreadsheet that was converted to PDF. You can just see that. But then if you go to the document properties, right, and so this will be a little practice tip for people dealing with this. If you just go like File, Properties, and you poke around a little bit, you could see that under the author field, it was like Microsoft Excel. It was like the metadata clearly showed that somebody had converted it from an Excel spreadsheet into a PDF document, right? So Pat follows up and says, "Hey, I can tell that this originally was Excel, and that's what I want," and they just completely blew it. So we ended up suing it, and one of our arguments was the guy lied. He was an attorney at PACE. One of our arguments is he lied. He said that an Excel spreadsheet didn't exist, and it did, and we can prove that it did. Now we're in the process of getting this thing worked out, but they've since produced the document, and they're going to agree that, you know, if someone asks for it in Excel, they have to determine it. So this is just sort of the kind of games that you see public bodies playing. I mean, just produce the spreadsheet. What's the big deal? Yes.
Did you go to the ARDC about the lawyer lying in that?
No. I mean, well, first of all, like, as a lawyer, it's unethical for me to use the ARDC process to sort of gain leverage in litigation. I mean, like, their argument was, well, we didn't say that it. He didn't flat out say, "I don't have it in Excel." Pat asked for it in Excel. He produces a PDF. Pat said, "Don't you have it in Excel?" He says, "Sorry, this is mine." So they were trying to chalk it up to sort of a misunderstanding or sort of a cute interpretation. No, but that's, you know.
But that being said, I mean, you know, the ARDC is an avenue, not that they're known as the most aggressive enforcement agency, but I mean, that is an avenue that we've kind of come to embrace a little bit, which is that if there's a public sector attorney doing wrong, or a former public sector attorney that's done wrong, we're not going to let it sit, and at least, you know, throw it out there and say it appears that so-and-so violated, you know, the canons of ethics, and let them kind of take it from there. In fact, that's one of our kind of our new, this year, I mean, it's always been sort of one of our sort of philosophies and areas of interest, is not just to expose, you know, bad behavior in government, but also to, you know, kind of light a fire under regulatory agencies to do their jobs. And, you know, whether it's the ERDC or the State Board of Elections or any of those, you know, types of regulatory agencies.
Yes?
I've had agencies say to me, it's a courtesy if we were to compile this information for you. We're not required to do so. So I just want to make sure, so if an agency has the raw data to answer the question that you want answered, but they've never pulled it together in the way that you want to know it, is it legit for them to say, hey, we don't have to do this because we don't already have a previously existing report that shows it just like this?
Yeah, this is an issue that comes up a lot, and there's still cases that are kind of fleshing this out. The way I would argue it, and I think it's right, is that each individual entry in it, I mean, usually this happens in like in a database. There's a bunch of data in a database, and you want only some of that data out of the database. You want all the zip codes for people that meet some criteria. So they actually would have to go do a quick little query, and then they could generate that document, right? So you're actually just asking for, I mean, each one of those records is a separate individual record. So I don't agree with the argument that, oh, well, we don't have to compile this for you. And in fact, that would mean then that you could never get data from government databases unless they just dumped the whole database on you. I mean, it really isn't any different than saying, you know, pull for me the paper documents out of a file that meet some criteria.
So if you know they have the raw data to answer the question you're asking, you're saying that this is something that could go to litigation?
So asking a question is a little bit different issue. So they're not, this is the example I give. If you were to send a FOIA request that says, tell me how many police cars you have, they don't have to write you a letter back that says we have 150 police cars. So what you have to do is ask a FOIA request that says, produce documents sufficient to show how many police cars you have. And then they'll really have to figure out what's the document that shows that or documents that would show that. And in a lot of instances, yes, because they don't want to have to go through that, they may just write back a letter and answer your question and say, we're not required to answer the question, but in any event, here's the answer.
But clearly they have the data somewhere to show how many cars they have. But if they never have created a report before my request to show it, you're saying that by law, I should be able to get it anyway?
Well, you should be able to get the documents that would allow that calculation to be made.
Okay, because they claim no. They claim we don't have to give this to you unless we have already compiled the report that specifically says how many cars there are.
I see that argument all the time. You can ask for documents in a sort of categorical fashion to say documents sufficient to show something. And again, if you're talking about data out of a database, then there's the provision in the statute that talks about electronic records, what I quoted a minute ago, and I would apply that against that and say, that means I want you to run this query and extract this data out of the database. Mm-hmm. So, but that does come up, and some courts have gotten that wrong, and it's still kind of being litigated. It hasn't been settled. But there is a difference between asking for the data and asking for an answer to the question. Does that make sense?
Mm-hmm. How many of you guys use like the terminology document sufficient to show? I mean, that's one of the things that I thought like I really do FOIA until I really started, you know, for the past few years working with Matt and his colleagues. And that's one of the kind of the tricks of the trade, so to speak, that we use all the time, and we found that it's been a lot more successful in terms of getting what we want. You know, instead of asking for a specific document, because a lot of these agencies will play games. Well, specify exactly what report you're looking for. You know, it's like, well, I don't know what your jargon is. So instead of saying, well, I want your, you know, ABC +2 report, you know, I say I want documents sufficient to show X, Y, and Z. And that way, the ball's in their court in terms of, I don't care where you gather. I mean, there's a downside to that, because if you want a specific document, you might not get it. Yeah. Okay, but if you're not looking for a document, but you're looking for a specific piece of information, you know, then that they can get it how they get it. They draw it and they just give it to you. So that's sort of almost like an end run around to ask the question phase, like, you know, tell me how many police cars you have. That's sort of how to get around that.
And a couple other things you can, I always tell people, whatever the thing is you're interested in, ask for the policies and procedures related to that thing. So if it's, you know, payroll, or let's take expense reimbursement. You want to get all the reimbursement requests, all the expense reports by somebody. Also ask for the policies and procedures related to expense reporting and reimbursement, because that might help you to identify what they call documents, what the process is supposed to be. You'd be shocked though how often there isn't a policy and procedure for something that you would think there has to be one. Like it's like employee expense reimbursement. I've seen public bodies have responded and say we don't have any policies for that. Really? So people either have government issued credit cards or they're getting checks back for expenses and there's no policy or procedure for how to do that. Somebody had said, was it with you guys? They had said, they said they had nothing. We're like, really? That doesn't make sense. And what about this thing that we'd heard about? It's like, oh, that's a directive. That's different from a policy or procedure. So I a lot of times say, get the thesaurus out when you're putting the request together so you can close out this.
Well, you raise a good point. I mean, there's a lot of semantical games. This is, I'm sure, not news to most of you, you know, in terms of, you know, directive versus a guideline, you know, that their jargon, they will try and embrace their jargon as a shield. And that's why one thing that we do in terms of our FOIA writing is we're not ashamed to like write like a FOIA almost like in like a child would. You know, we'll ask for it, you know, document sufficient to show X, Y, and Z. Then the next paragraph will say, in other words, what I'm looking for under FOIA is, you know, X, Y, Z. And to be clear, what I mean is this, and you know, I will say it 3 times, and they'll probably look at me and say, hey, asshole, we get it, but at least then I won't get a denial, you know, or I'm less likely to get that. So I mean, we really do, you know, we try and put it in English. You know, I've worked with people before that write these big legalistic, you know, you got to remember who the FOIA officers are in a lot of these cases too. They're not necessarily attorneys. They're not necessarily, you know, that well versed in the law. They're more paralegals, secretaries, and stuff like that, or it's just kind of all-purpose bureaucrats. Make it so you put it in English, very plain, simple language. First of all, so it can, you know, you can kind of convey what you want to whomever's, you know, interpreting it, but also so there's no wiggle room and they can't play semantical games. And one last thing, just kind of pivot off of what Matt was saying in terms of, you know, when we were talking about our payroll stuff, because one thing that BJA has done for years, instead of just doing stories, is we kind of throw content online. And one of our major elements of content is our payroll database, which is woefully behind right now. We're in the process of updating it with more current numbers, which is basically any government, or not any, but many government employees and their salaries and their agencies and stuff like that we have on our site, which means we put out hundreds and hundreds of FOIAs. And that's why we ask for things in Excel, because it's more easily convertible to what we have up on our site and everything. But we did find one municipality that after they realized why we were asking for it, that we wanted to put all the employees up online and, you know, do that, we believe, at least we didn't prove this, but I mean, the fact is they did change their format, so they no longer have their payroll in Excel. And so, I mean, and that was, and we believe in reaction to us. So that's just one illustration of like the many, not that this is news to a lot of you, like Christy, you know, is on the front lines too, you know, that there's just a lot of challenges, constant challenges. It's like a war. And even though we're like probably on the more aggressive end of like litigating and fighting and pushing back on this, we still see a constant headbanging, like stuff like that. They try to end run us, if not fight us outright. A couple examples of that legislation, which a lot of people that don't cover the General Assembly a lot, or that aren't monitoring stuff like, you know, like the Headline Club, probably don't realize that with every legislative session, or many legislative sessions, there are FOIA bills out there that are just designed to erode FOIA, even though FOIA is better than it was in some ways, and it's still not perfect, and it should be improving, not, you know, not devolving, and yet there are, there's constant legislation out there to erode FOIA, and it has to be beaten back by groups like the Illinois Press Association and sometimes us. So that's one kind of battle that we constantly see. And
Can I add on top of that? So the argument that's often made is it's just very expensive to deal with FOIA, and we have other things we need to do, and we get so many FOIA requests. So I handled a case against a municipality who was for just a group of individual people who had just been pretty much ignored for like a year or more worth of FOIA requests. And it was a stack like this where it was just either there was no response, or there was, we'll get you the documents, and then like 8 months would go by. One of the things they had asked for was expense reports expense reports, credit card statements for a credit card being used by the village manager. And they were told that he didn't have a credit card or any expense reports, which they knew wasn't, they knew it wasn't true. So we filed the case, and they threw all kinds of stuff up about, oh, we weren't, we were going to answer these FOIA requests, we're just so overtaxed and overburdened that, we just, you have sympathy for us, Judge, because we're just doing the best we can. So then it comes out that they did have these expense reports and credit card bills. And so they produced it to us. And there's like tens of thousands of dollars in charges for like outings in Soldier Field for like a college football game and out of town travel to go to conferences. And I mean, maybe there was some legitimate reasons for some of that stuff, but at the same time they were complaining that, we did our best, but we just didn't have the resources to deal with these requests. They were spending, for that money they could have hired a part-time clerk to clear the backlog of the FOIA. So it's really just a matter of setting the right priorities. And FOIA, there is good language in the statute that says, notwithstanding the financial obligations, this is an important thing, and public bodies have to respond to it in time. But that's just a constant battle by probably most public bodies to try to scale that back, get more time, broader exemptions, make people pay more, things like that.
Well, and completely claim that they don't have to adhere to FOIA at all, which is what we're seeing with now state's attorneys across the state, or at least not all, but there's, you want to touch on that?
Yeah, so I think it was the Kane County state's attorney took the position that the state's attorney is part of the judicial branch. The judicial branch is not subject to FOIA, so you can't do a FOIA for individual judges' records. The clerks of court have taken, like Dorothy Brown's office says, we're not subject to FOIA either, but we generally will give you documents if you ask for them. There are some court decisions that have gone in her favor on that. So, notwithstanding the fact that there have been state's attorney FOIA officers for a long, long time, and state's attorneys have responded to FOIA for a long, long time, I think it was the Kane County, I might be mistaken, I think it was Kane County. The state's attorney said, no, we're not, we're part of the executive, we're part of the judicial branch, we're not subject to FOIA. And they won that, and they won it on appeal. And that's now sitting, the Illinois Supreme Court took cert on that, so that's going to get resolved hopefully pretty soon. PGA signed on to part of it, an amicus brief along with the press association. Kendall County, I'm sorry, no offense, King County.
They've got the same way.
What's that? Yeah. Yeah, so, yeah, it's just, and it's funny because they're on this, I think you're having the same issue with Cook County, right?
Well, yeah, I mean, and also the thing is, even those are still pending before the courts, right? I mean, they don't have to be embracing this. They could wait for this to be resolved, and yet some of them are actively jumping in and saying, oh, the court said, so sorry. But, so I mean, their commitment to transparency is ridiculous.
Well, then you have to ask, well, why did they hire somebody to be a FOIA officer and spend public money on stuff like that for so long? I suppose they could say, well, we were just voluntarily. This is just a creative argument that some lawyer came up with way after the fact. And I think, especially when you get outside of Chicago, the further you get outside of Chicago, some of the courts are less stringent on FOIA. I think generally, like in Cook County, the judges are pretty good. They generally get it. Not always, but they generally pretty good on FOIA stuff. So at least in my opinion.
It's hard to imagine they're worse than but I guess.
Yes.
So for those of us who work in newsrooms that don't really have lawyers to, cut our FOIAs, that was for us. I mean, realistically, if we call you guys up, like how often are you able to invest much time, given how many of us are, facing these hurdles?
Right. So, I mean, the statute does provide that if we prevail, then the government has to pay the attorney's fees. So, in appropriate cases, that's part of my practice is to take those kind of cases. I suspect I might get overwhelmed with phone calls potentially. So,
I mean, are you typically of the sort of caseload that you're handling right now, are most of them started with stuff that BGA was investigating, or is it stuff
A very good percentage, but not exclusive. But I mean, one thing that we do as well, I mean, I'm not an attorney, but we field calls, and we're happy to field more. Just for, I mean, like I said, we toil in this every day. I mean, last year we counted, we put out I think a couple thousand FOIAs last year. I mean, a lot of it was for the database and stuff, but we kind of, with the help of Matt and his colleagues, really kind of come to understand these pretty well. So we don't advise from like a legal standpoint, but we do advise from, a practical standpoint. If reporters from other news outlets call us and say, I've got this roadblock, how would you go about it? We're happy to sort of give some thoughts and give some advice. And also, what some news outlets have done is they've asked us to kind of team up with them on a story, which sort of gives us sort of standing that if that we can reject it, then we can sue. So we've actually had, sometimes done that with us, and that once we're involved, because some of these agencies know there's sometimes, other places in the world won't necessarily sue, sometimes they will, but that if they get us involved, we have those resources that other people don't. It's not that we can do it all the time. So that's one thing. The other thing is just advice and just kind of kicking around with somebody. Several people in our office are really pretty expert at FOIAs who are not attorneys too, but that's always an option.
Yeah.
How successful are people who do it pro se, just do it themselves and sue?
Some people have been pretty successful. Not always. I think generally non-lawyers bringing lawsuits kind of they don't understand how to transition like what would seem to make sense in the real world to how you do that in a courtroom. So there's varying degrees of success. But there's a guy, his name is Warren Garlick, who he's been he's had several appellate decisions. They've gone both ways, but he's won at the Illinois Appellate Court on stuff. So he's good. I've met him over the phone a few times. We filed an amicus brief in a case that he had filed, and he did reasonably well. The other option, you can take these to the Attorney General's office, to the PAC's office. Has anybody done that? Some? Okay. Yeah, I've had cases where there's been an adverse decision from the PAC's office against a client, and then we filed a lawsuit, we effectively got it flipped. So sometimes, I think if it's when it's straightforward, they generally get it right, but not always. And I've seen them be on the wrong side of things, a few times. I think in general, sometimes they're just sort of practical about it, sort of loosely practical about it, instead of really strictly reading the statute and interpreting what the statute says. It's almost trying to find what's a reasonable outcome for this, and that's just not, I don't think, the way to be going about it. The statute says there's a thumb on the scale of producing documents, and documents are assumed to be subject to disclosure unless an exemption applies. It has to be proven by clear and convincing evidence, by which is an enhanced standard, and that really everything is supposed to favor transparency unless it's very clear that there's an exemption that applies, and you have to interpret those very narrowly. And I have seen acquisitions that I don't believe comply with that.
And also, even though we're sitting here saying, oh, we sue, we're fairly successful, there are a lot of examples of people that don't sue and are successful about getting what they want. The Sun-Times, a lot of this Koshman stuff has utilized FOIA, utilized the PAC's office, has been successful. This case here, you guys I'm sure read about this thing with the police department, and it's just Jimmy Calvin, independent journalist. I don't know tons about this case, but just what I've read. But listen, there are success stories in terms of,
Yeah, and actually
with people unaffiliated.
My new firm was, along with the University of Chicago clinic, was involved in that case. So that involved CRs, which are complaints against police officers for excessive force or misconduct. And the city had said that they were not subject to, or they were exempt under FOIA under an exemption that applies to the adjudication of complaints. These actually aren't the adjudication of the complaint. This is the